you die without a will, you're going to go to probate court. The difference between a will and not having a will is if you don't have a will, we apply the statute to you as to who your heirs are going to be. If you have a will, then we're going to follow those instructions. The judge will follow those instructions and give it to whom you chose. Probate's traditional process is we can get the first hearing within 6 weeks to get letters. At that point, it opens up the creditor's claims. That's when the creditors will all be put on notice that, hey, someone died and they may owe you money. At the first hearing also, that's where people get to start challenging whether or not they're an heir. And then after the creditor's claim closes, if no one's contested it and the claims have been paid, then we can file for final accounting and discharge. So the probate process is can be best case a year, and it's very expensive. The bad news is the probate process, if one thing goes wrong, one person shows up at that first hearing and says, no, I should be the executor, not them, that's going to kick you out another 6 months. Just right out the gate, because it's so strictly scheduled. So when you do business with us for probate, we're filing your publication, which is required. You got to put something, believe it or not, in the newspaper. Like anyone's reading that, right? But you put it in the newspaper, and you say so-and-so died, and that starts the period. If you don't start, we start the publication before we even file. Because that first hearing, we've got to make sure that that's finished, or else you're not going to be able to move to the next one. And if you miss your time frames, it's not going to be a year, it's going to be 2 years or 4 years, because they don't have another date for you. So that's one of the problems with probate. So that's kind of the stuff that goes to probate, is anybody who has a will, anybody without a will. Here's some things that don't go to probate. No probate, I'll call it. One thing that doesn't go to probate is anything held in joint tenancy. You guys ever heard of joint tenancy? Like we're joint tenants? Yeah, or joint owners on an account. So if you're joint owners on anything, that doesn't go to probate, because joint tenancy means you both own an undivided whole. If one of the parties dies, the other party owns the whole. Okay? Joint tenancy is the strongest way to hold property. Here's something people don't think about. I'll be joint tenants with one of my kids, and then I'll have a will, and I'm going to leave the property to all three of them. You die, joint tenancy's first. That will is not operative against that property. These two children are disinherited, even though you had a will. So joint tenancy is the strongest way to hold property. Biggest problem with joint tenancy is you both own it. So I have a case where parents put their child on the house, joint tenancy, child got married. It's always the spouse. It's the problem. It's always the spouse, right? Child got married. Spouse said, well, I want to get our own home. We can't have our name on that house to get a mortgage, right? So he filed a partition action against his parents, even though he didn't pay for it. Partition action is where you say, I'd like the court to sever our joint tenancy and pay me my half. Remember, when the parents put him in joint tenants, they basically gave away an undivided whole to the child. Now he's suing his parents to get his half. Cost the parents $13,000 to settle with the kid. So that's one problem with people that do their estate planning by using joint tenancy, is you're giving them the interest now. They can take the money out of the account now. Also, if they get in an accident and kill somebody, that account or that house is reachable by the attorneys, right? Because they own it. So there's another problem putting things in joint tenancy for estate planning purposes, although it is the strongest way to hold title. Another thing that doesn't go to probate is anything that has, and if you guys ever heard of a payable on death beneficiary? A payable on death beneficiary might be on a life insurance policy or on your bank account. You say, hey, if it's a simple form and you say, when I die, give it to Joe. That payable on death beneficiary is not a present interest, so it's not joint tenancy, but it does avoid probate. It is considered an irrevocable trust the day you die. So if you die and there is a payable on death beneficiary on your account, It's an irrevocable trust for that person. All they have to do, bring the death certificate, and it's theirs. Now what if you said, I'm going to name my son the payable on death beneficiary, but I'm going to make a will and I'm going to provide for my 2 daughters and my son. I'm going to say they all get that account. The will will not have any effect. The payable on death beneficiary is a trust, irrevocable trust. That one child will get it. The will not have any effect as to that account.
May I ask a question? When you have a trust and you name your child as beneficiary, is that the same thing?
We're going to do that in a minute. Would you hold that for 1 second?
Okay.
I'm just going to do one more thing on this, things that don't go to probate.
Okay.
Things that don't go to probate also are trusts. So that's a great lead-in. If you have a trust, you don't go to probate. And there's a reason for it. So the concept of trust is really, really old. It's one of the oldest rules of law. It's English common law. It's basically, I'm going to give you my sword, and I'm leaving the country. If I return, give me my sword back. But if I don't return, give my sword to him. That's trust. That's how it was created. It's holding property that is not yours for the benefit of another, right? And so when I handed it to her, you know how people used to say like possession's 9/10 of the law? But when I handed it to her and I left it in trust, that possession didn't constitute ownership. That's the theory of trust. So if you look at this page, if they want a page, the second page of your handout, these are the 3 parties that you have to have a trust. You didn't get one? Okay. So this is how you know you have a trust. Because you have a trustor, also sometimes called a settlor, also sometimes called a grantor, but that's all the same person. Here's what this person's doing. This person's giving the money to the trustee. That's the worst job, right? Being a trustee is the worst job. That means you have to do all this for the benefit of someone else and get nothing. And they're managing that property for the beneficiary. That's the third party. That's the best job. You get stuff and you don't have to do anything, right? So, some genius came up with this idea that, well, what if I put property in a trust? When I die, I wouldn't have to go to probate because the property isn't mine. It's not mine anymore. It's my trust. So, that was the concept. And because there's a rule called the statute of frauds that says everything for death has to be in writing. Everything pertaining to property at death must be in writing. What we do is we create trust agreements in writing that say this person is giving it to the trust, this person's managing it, this person's benefiting. Now here's where it gets weird. If you have a revocable trust, what it says in the opening paragraph is, I am giving my property to myself to manage for my own benefit. That's pretty weird, right? You're making an agreement with yourself to manage it for your own benefit during my life. That's legal fiction, right? That's not real stuff. That's legal fiction. But the magic happens in your trust is it says, but when I die, it will name the successor trustee. It will name the new trustee. And because you're dead, it will name the beneficiary. That's the magic of it. Not while you're alive, but once you die, it becomes irrevocable. And now we can see who's doing what with the property. If you're picking a trustee, are you happy with that person? And is that person going to do what you want? The trustee is the worst job. So the person that would least like to do the job is usually the best one to pick. Right? You know, if somebody says, I really want to be the trustee and do all this work for free, I would suggest that they may want to steal or do things that you don't want them to do. Nobody should want to be the trustee. The banks are getting out of the business of being trustees because it is so awful. The beneficiaries want accounting. They want this. They're questioning you. Why did you do that? Why did you sell this? Where's this stock? Why did you make this investment? So be careful with who you choose. Are you happy with your trustee if you have a trust? Think about who you named. Are they even around anymore? So that's a really important person with your trust. Is your trust funded? Gosh, is this one important? You guys run into this probably all the time. A trust is a basket, and it can only do stuff with stuff that's in it. And how do we put stuff in the basket? We title it in the name of the trust. So, some people get this beautiful trust written, and then they get instructions, because the person that drafted it didn't want to do the extra work. They get instructions on how to put stuff in it. The people go, I got this great trust. They don't read the instructions, they put it in the drawer. They die. And what do you find? That the title of the property, the grant deed says the person's name. The decedent's name is on the grant deed. The trust can't help you because you didn't title it in the trust's name. It can only help you with things that go in the trust. Anything left out, the trust will not help. So they left out a house because they didn't put the grant deed in the trust name. Now what do we do? So that's when we have to, as lawyers, go either file a petition for a Hegstead petition with the court to try to get the court to bless us and put that property in the trust, or we have to probate it. The Hegstead costs between $4,000 and $6,000 to do.
What?
A Hegstead petition. A petition to say, hey, they forgot to put this in the trust. We would like the court to order it in the trust. That petition costs between $4,000 and $6,000 to get done.
Well, who's the they that forgot?
It's the person who got the trust made by the person. So they got a trust made for themselves, and they never put anything in it. So they have a beautiful basket that is empty. You have to title all the property in the name of the trust for it to work. Your bank account needs to say, the trust of Mary Jane. Your deed, your real property. The trust of Mary Jane. It can't say Mary Jane. It has to say the trust of Mary Jane, the actual name, for it to work.
So, I'm sorry. I just want to make sure, because I'm always, well anyway. So my trust that I have now.
What's the name of your trust?
Eleanor A. Fulver. Eleanor Ann Fulver.
Eleanor Ann Fulver Trust. Okay. How do you spell that? Let's do an example. So the name of the trust is the Eleanor. Is it E-L-E-A-N-O-R?
Yes.
And then what's the last? A-N-N? A-N-N. And then what's the next name?
Fulver.
How do you spell that?
F. Like Frank. A-U-V-E-R.
V-E-R. And is it say living trust or say trust?
I think it says living trust.
Okay, living trust. And it's probably dated.
Yes, it is.
And it's going to say dated. I'm just going to make a date up.
Yeah, it's okay.
Dated May 5th, 1990.
Right.
Okay. That is the name of your trust. So anything that is in the name of Eleanor Ann Fulver when you die is probably subject to probate. Anything that is titled in this name will not have to go to probate, and the trustee can handle it.
So that's where I'm interested, because I have only my son as beneficiary.
Okay?
So, but it doesn't say trust.
On your account, it doesn't say trust. When you get your bank account, it doesn't say the Eleanor Fulver Living Trust.
It does.
That's good enough.
But my son is the beneficiary.
Right.
I don't have Eleanor Ann Fulver Living Trust and my son, Roderick Hall.
You don't need your son on it.
So just so his name's on there.
Yeah, you wouldn't need your son on there. If it's in the name of the trust, and the trust names him a beneficiary, he does not need to be on the account. It's set. The trust will administer that account.
So will he have to go to probate?
No.
If anybody argues with him, fusses with him, it's still, he's the one. Nothing.
Correct.
Nobody can interfere with that
Correct.
at all.
Right.
Okay.
And he won't be going to probate. So what he'll do is he will provide a death certificate and his trust certificate, and then he will pass out the property as you've directed. I don't want to get into too much detail unless somebody really needs to know this, but definitely bank accounts. If you have some stocks and bond accounts that are not qualified money, meaning they are not tax deferred, then you would want to put that in the trust. If you have qualified money, tax deferred money, we really need to talk about that before you put it in a trust. The Trump tax changes made an automatic burnout on retirement funds that are tax deferred. And if they go to an estate, it's a 5-year burnout, meaning your heirs have to take your entire 401k over 5 years and pay all the taxes. So we want to make sure we talk about those things before we just put a retirement account. I'd rather see, if you're not sure, name the beneficiary on the retirement account on those best beneficiary designation forms. Because then it will be based on, it's going to a natural person, and then it's going to go on their life expectancy, which is tax advantage to them. Other things you can put in the trust, what we do is most trusts have like all my personal property, it says, is in the trust. You don't have to do anything special with that. And that allows your trustee to go ahead and hand out your personal items the way you'd like, or sell them. Cars, we use affidavits. After death, the trustee can go use an affidavit to transfer the car to whoever you tell them to give it to. We don't usually put the car titled in the trust, because if you bump into somebody, they're going to think you're rich. And they're going to sue you. They may not even take the insurance tender. So we don't put, we don't at our firm put cars, we don't title our car in the name of the trust, because in case you hit somebody, we don't want them to think there's more there than the policy. And cars are super easy to transfer. It's a form online with the DMV. So we can just say, my 2022 Escalade goes to my niece. We'll put it in the trust. The trustee will do the affidavit and transfer it.
So what's the purpose of having a will if you're going to do all that in the trust?
When we do a trust package, we do include a will in case our client did one of these. And that they die, and we got this in the trust. Cool, this is easy. We handle all this, but we got these 3 things, these 3 pieces of property that aren't. We take that pour over will to the judge, and we probate those 3 items, and we say, please, judge, we want to administer these by the terms of the trust. And that's why we have the will. Because if we don't have the will, putting it back in the trust, so let's say you said, I want all my personal property to go to the church. I hate my children, right? I hate my children. I want all my personal property to go to the church. In the trust, it says that you don't have a will. You leave this stuff out of your trust. When you die, you will have died intestate, meaning no writing. The trust can't deal with this property. It cannot put it to the church, and it will go to your heirs in an even split.
And that takes sometimes years. And
Yep.
Well, how do they pay for all this years of who just comes in and handles it? Do they get
We
paid?
do. Attorneys do. And we get paid by everything that's in that estate.
Okay, that's what I'm trying to figure out. Okay.
So are we good with, did you properly fund your trust? Did you put the assets in the name of your trust? You guys comfortable with that? Because that's the biggest mistake we see, is these beautiful trusts and people forgot to put the assets in the trust, and so they're sitting here. You have, this here is a recipe for disaster. I only do it when the client makes me, and I send them a letter afterwards telling them this is a bad idea. Multiple trustees is a very bad idea. Multiple executors is a very, very bad idea.
Well, he's in Kentucky, she's in California. That was the main reason.
Great, but it's great because
But I
it's a
do
good
not-
idea.
She's slow at reacting and doing things.
Right.
And so he might as well just figure it out.
Right? Because why? Because if you have 2 trustees, they have to act unanimously. And they may not see the world exactly the same. They could be actually on the same page in most of their life, but one says, let's not sell this year, let's rent, and one says, we need to sell it right now. And they're doing it for whatever reasons. And then you could have a fight in court between the trustees on how to administer the trust properly. You're not even getting to the beneficiaries. So I don't like this. If you have this and you say my kids would never fight, then that's fine, because I have done that before. But be aware, when you say my children will never fight, it's not your kids that fight, it's their spouses. It's a spouse in the ear of the child. You're not getting your fair share. You need to do this. And then the kid lashes out at the other brother and sister because of the pressure they're receiving from the spouse. And then they fight. And then things drag out. So you want one, I mean, in a perfect world, right, our trustee would be this fabulous person that has such great intentions, that's not related to us in any way and is not a beneficiary, and they're going to handle everything. That's in a perfect world, but who has that? And so we have to rely usually on family members that we think are the most judicious. Yes, sir?
Yeah, in my original trust, I had co-trustees.
Yes.
And I found out some banks won't honor that.
Yeah, they won't even allow it because they don't want to get two signatures.
Right, so I had it altered.
And you have to explain to your children,
Yeah.
I'm not doing this to punish you. This is a terrible job.
Yeah.
This job is awful being a trustee. And if you want to do the job, then I really don't want you doing it. Because it's terrible. You have to do this accounting. You've got to manage all this. You've got to listen to the beneficiaries gripe at you that you're doing everything wrong all the time. Okay, so we're comfortable. Any more questions? I know I'm harping on this, and you guys might be like, Dave, come on, let's move on. But I just want to make sure our trusts are funded. So if you go home, look at things later, make sure that the things are in the name of your trust.
Funded is what again?
Means it's titled, the asset is in the name of the trust. Now, you had suggested that you already had payable beneficiaries on the account, so that's just as good. Okay, next, we talked about that. Are you happy with your trustee? Because they're going to be the ones that have to do the heavy lifting. The third thing that you always want to think about if you have a trust is, are you still happy with the way the beneficiaries are going to receive things? So, without boring you today with too much, we have an option when we give beneficiaries things. We can give the gift to the beneficiary outright, meaning here it is, here you go, have at it. Or you can leave the gift to the beneficiary in trust. Another trust. And it doesn't take, you don't have to build another trust, it's just inside of your trust. You say, all of the benefits for Susie, though, will be held in trust for Susie for her welfare, well-being, education, whatever terms you want to put on it. And this person, and you name the person that will be the trustee of the Susie Trust. All of our trusts we do have backup language that even if you're to get a gift outright, if you are incapacitated or on public assistance or receiving some sort of government health care and you don't want the gift because you are disabled in some way, all of our trusts say that the trustee is allowed to declare them such a person and keep their money in trust and only give them disbursements in accordance with those benefits. Ours also say if you're under the age of 25, that gift will be held in trust till they reach the age of 25, then they can have it outright. That's just a default we use as a backup in case any of the beneficiaries fall under circumstances. But you can decide that Susie's never been good with money. Susie gambles. Susie drinks. Susie gets in trouble. Susie has liens against her. And if Susie has judgments and liens and drinks and gambles, I mean, Susie's bad, then maybe I don't want my money to go straight to her creditors. And in that case, you would want to leave Susie's gift in trust her. Okay? So that's what we have to think about when we think about beneficiaries, is do they get the gift outright or do they get it in trust? And then the last thing with beneficiaries that we always have to talk about is if we have, let's say, 4 beneficiaries, and let's say they're all equal beneficiaries, 25%, even though they don't have to be. If one predeceases you, leaving 2 children, does this beneficiary's gift go to the children of that person, or do you want it to go over to your other children? Do you want the gifts to go down to grandchildren or not? That's something you have to decide. If you say, I want it to go down, if they predecease me, I want it to go down to their issue, their children, then the next thing you have to decide is, do you want the gift to go straight down? So if this person's getting 25% and 25% and 25% and 25%, the question is, if 2 of them are dead, do you want this 25% to be divided by 2 grandchildren and this grandchild to get a full 25%? Meaning this one gets 12 and a half, this one gets 12 and a half, and this one gets 25? Is that what you want? Or do you want it to be reset at each level? Meaning that they would each take a third of 50%. So that's the kind of the last thing in the basics that we think about when we talk about beneficiaries. So let's just do this clearly so that I don't commit malpractice this morning. It's a little early in the morning for malpractice. I usually do that around 3. So what's the name of your trust?
Jerry R. Douglas Trust.
All right, so we're going to call it the Jerry R. Trust. And we know that that's owner 1. And who's the other owner?
My daughter Robin.
Robin's an owner. Owner 2? Okay. All right. So, and how is that ownership held, do you know? Is it joint tenants?
Yes.
Okay. And then the trust would say that, hey, this account goes to who?
To Robin.
Robin here? And who else would the trust give it to?
My daughter Wendy.
Wendy. Okay, is there anyone else the trust is giving that account to?
No.
Okay, so they are supposed to get a half and a half?
Right.
Okay, so what could happen here? What did we talk about? Robin and the trust are joint owners, right? Now, the trust, though, here's the tricky thing. The trust can't die. So you're not going to see this. And basically, a trust can't be joint tenants with anyone, even if you think it is. So these two probably more than likely, hold the account as tenants in common. Tenants in common is much different. That's 2 undivided halves. So what he's done is he's made the account broken into 2 halves. So Robin would take, she already owns a half here, and the other half will be broken up between Robin and Wendy. That's how that would go. If everybody stood on the rights. Now, Robin may be a super nice person and say, no, Dad really meant for us to split it 50-50. But if Robin isn't a nice person, especially when the power vacuum happens, when somebody dies, there's a power vacuum, and then everybody can be who they wanted to be all these years. Robin theoretically could leave with three quarters of that money.